Information Officer for the City of DeBarry. In about 30 seconds, our City Manager is going to update you on the next steps the City has taken in regards to the property at Spring Vista. And after that, we'll take some questions from you all at the press and give you some more information. So now, Carmen Rosamunda.
Thank you. Good morning. The purpose of today's conference is to provide the public the City of DeBarry's position and intent regarding a potential Volusia County school at the Spring Vista site. On Monday, April 28, 2025, the City of DeBarry issued a letter demanding the school board cease and desist from any further efforts to design, engineer, or construct a school on the Spring Vista property. We issued the letter to be proactive, as Volusia County Schools will be spending a lot of taxpayer money on design, engineering, and other pre-construction costs, only to realize they cannot legally build a school at the Spring Vista site. Trying to build a school on this site will violate our statutorily required interlocal agreement and Florida law concerning the city's comprehensive plan. Let's keep in mind that Volusia County Schools, after an extensive due diligence period, already purchased 48 acres in the southern part of DeBarry. The City Council approved this site on July 3rd, 2024, and Volusia County Schools closed on the property on July 11th, 2024, paying $4.8 million. So let's talk about the statutorily required interlocal agreement. Section 163.31777 of the Florida statutes requires county and municipalities within a geographical area of the school district to enter into an interlocal agreement with the school board district. An interlocal agreement was executed in 2003 and amended in 2007 by Volusia County School Board, and all 16 Volusia cities. The Florida Department of Community Affairs and the Florida Department of Education also reviewed and approved this agreement as being consistent with Florida law. Section 3B1 of the interlocal agreement states, quote, "The local government's review is limited to consistency of the comprehensive plan, environmental concerns, health, safety and welfare, and the effects on adjacent property." This is what all 18 governments in Volusia agreed to. That is, the local government decides whether a site meets these criteria in the local interlocal agreement. Let's talk about the comprehensive plan. Under Florida statute 1013.33 paragraph 4, it states that the location of educational facilities shall be consistent with the comprehensive plan of the appropriate local government body, developed under Part 2 of Chapter 163, and consistent with the plans implementing land development regulations. So on or about October 18th, Building Tomorrow Schools, as agent for the school board, filed an application for consistency determination. On or about November 13th, 2024, the city staff issued a response advising the Building Tomorrow Schools that the Spring Vista site was not consistent with the city's comprehensive plan. Building Tomorrow Schools appealed the decision to the City Council, whereby under Florida statute 1013.33 paragraph 5, the City Council conducted a 4-hour quasi-judicial hearing on January 15th, 2025. After relying on substantial and competent evidence, including testimony and documentation provided by expert planners and engineers, as well as overwhelming testimonies from residents against this site, the City Council determined that the property failed to satisfy both the city's established criteria in the comprehensive plan and standards outlined in the interlocal agreement. Volusia County Schools did not file an appeal on the City Council's decision under Section 163.3215 of the Florida statutes in circuit court within 30 days following the rendition of the decision, or exhaust all administrative appeals. Therefore, the City Council's decision that the school at the Spring Vista site is inconsistent with the city's comprehensive plan is final under Florida law. Yet, on April 22, 2025, Volusia County School Board decided in a 4-1 vote to purchase the Spring Vista site for $8.4 million. In this meeting, school staff confirmed that design and engineering for the school on the Spring Vista site is underway. Volusia County Schools can buy any property they want. However, the city's position is that it cannot build a school at the Spring Vista site without violating Florida law. The city's position is firmly supported by nearly 50 years of Attorney General opinions, and I'll go over 3 of them right now. Attorney General Opinion 2004, 2004, number 12, is the School Board of Hernando County versus School County Board of Commissioners, and it was written by Charlie Crist, the Attorney General at that time. And his conclusion was, at the end, and I'll quote, "Rather, the legislature has made it clear that school districts and school boards are subject to local land development regulations enacted to implement local comprehensive use planning and development. It is my opinion that development on property owned by the school district that is situated within the county must comply with the county's comprehensive use plan." The second one is from 1989, number 31. It's the City of Perry versus Taylor County School Board, and it was written by Robert Butterworth, Attorney General. Quote, "Thus, all development undertaken by and all actions taken in regards to development orders by school boards in regard to land covered by the plan," which is the comprehensive plan, "or element must be consistent with the plan or element. The language of the statute is clear and unambiguous. When the legislative intent, as evidenced by the language in the statute, it is clear and unambiguous that the statute must be given its plain and obvious meaning." And the final one is from 1979, number 37. It was written by, it was implemented by the Sanibel City Attorney, and it was written by Jocelyn Wilson, the Assistant Attorney General. And it's regarding the interlocal agreement. It's per statute, quote, "The interlocal agreement must include procedures for coordination on a new school site prior to the land acquisition and requires local governments to advise the district school boards on the consistency of the proposed school site with the local comprehensive plan. Development on the property owned by the school board, which is situated within a municipality, must comply with the municipality's comprehensive use plan." These Attorney General opinions confirm while school boards may be exempt from local building codes, permits, and impact fees, school boards are not exempt from local government comprehensive plans and land development regulations. Over the last 2 years, the city has worked hand in hand with the Volusia County Schools regarding on bringing a school to DeBary. Let's be clear, the city wants a school in DeBary that is beneficial not only to our kids, but also is compatible with our community. The city became aware of the school of Volusia County Schools wanted to build a school in DeBary in 2023 when the school board announced they were acting on closing Enterprise Elementary, which is located in a neighboring city. In the April 22nd meeting, the board admitted to extremely poor planning regarding this project. Land is a limited commodity in DeBary, as we are nearly all built out. In 2018, the city had hundreds of acres to buy land and build a school. In fact, in 2022, a perfect 30-acre site for school site on Fort Florida Road was sold to a private developer. But as you know, under Florida law, school boards must approve every single new residential development in Florida, guaranteeing capacity of new students. And under Florida law, cities cannot approve a new residential development without the school board issuing a certificate of capacity for those students. The state of Florida placed school boards in the development review process so they would have all the up-to-date information to plan for schools. All of the poor planning and missed opportunities by Volusia schools to buy land in DeBary has caused this legal issue. The school board's decision to purchase Spring Vista property and the school board's admission that the design and engineering for this project, which has commenced as of April 22nd, 2025, reflects a clear intent to violate the city's comprehensive plan decision, which is final and binding, and a breach the binding statutorily required interlocal agreement. One final word. Earning and keeping the public trust is critical in local government today. And purposely and intentionally violating the interlocal agreement not only violates Florida law, but destroys public trust for the other 17 government partners, as well as for voters as well. Damaging these trusting relationships may have long-term effects. Thank you, and I'll be glad to take any of your questions.
And let me just say, Eliana, in case you're going around, we are live streaming this, so obviously use your microphones, but in order to get your question on our live stream, Eliana is going to go ahead and speak into our microphone as well. So do we have any questions? Eliana, go ahead. Thank you.
Good morning, Laverne McGee, News 6. How far are you willing to take this legal action if the school board continues forward with that piece of land developing a school on it?
You know, when the city council passes ordinances and resolutions, they require the city manager to uphold those ordinances. Ordinances are passed on comprehensive plans. Ordinances are passed on land development codes. And it's my job as city manager to enforce those. And we enforce all these codes on every single parcel in DeBary. And so if indeed the school does want to break ground or clear the property, I will do my job and recommend to the city council that we pursue further legal action to prevent the construction of that school on that site.
Will you move forward and build a school on the land that you have proposed?
Well, it's not the land that we have proposed. The school board bought the 48 acres at Buckley. We've offered to work with them. We understand that there are some challenges with that property, but we believe that we can overcome all of those challenges or concerns. And we want to make sure that if we do build it on the 48 acres, we'll work with them as much as we possibly can to make it happen.
Channel 9.
How you doing? Daryl,
Great.
Channel 9. If this is happening already in 2025 because the growing population in DeBary, would this happen again for another plot that the district is trying to build on?
Well, the law is pretty clear that school boards have got to comply with all local government's comprehensive plan. The Comprehensive Plan Act was passed in 1975. And so there's got to be a tremendous amount of proactive planning by the school board. And unfortunately, in this case, if they haven't done that, and this is the problem that comes about with the inability to plan.
I'm trying to figure out a way. So this building is to make the commute closer for children and families. If they have to put it in a different place, won't this hinder the families that have to go to the school?
Well, if they build on the 48 acres, the 48 acres is only a half mile from the Spring Vista site. Both properties are on 1792. Both properties are going to impact 1792. This particular site, as we demonstrated in our hearing on January the 15th, has too many constraints against adjacent affected properties. And then the safety and welfare are also a concern. But it's just not consistent with the city's comprehensive plan at this site. So we can do everything we can to build on the 48 acres, which is only a half mile away. So.
Do you have other questions?
Yeah. You mentioned there are some challenges on the 48 acres. Can you elaborate on that?
Well, it does have a little bit of wetlands on it. It's 48 acres. It has approximately 10 acres of wetlands that need to be worked around, but it's still larger than this particular property at Spring Vista. Yeah, it is going to require some fill, but developers are in line to purchase this particular property, the 48 acres. They've already had offers to buy it. And so with some work with St. John's, with the county, with FDOT, we think that we can do some innovative stuff at this particular location and make it a really fine school for the school board and the city of DeBary.
Hi, so do you have any idea what the motivation is or what their agenda is? If you're talking about two parcels of land that are a half mile apart in the same city, in the city of DeBary, in the same county, close to each other, two parcels of land, what would be the motivation for the county school board fighting to have it on that piece of land that's not too far away from the other piece of land?
I don't know. You're going to have to ask them, to be honest with you. Certainly the 48 acres needs fill, but both properties need fill. And so both of them impact 1792. They both have concerns, but unfortunately this one on Spring Vista is not consistent with the plan, and the council has already approved the 48 acres for a school down at that particular location. Why they don't want to build on it, I don't know. Certainly it may be a little bit more money to build on it, but again, the lack of planning causes additional costs because your options and your opportunities are limited.
So follow-up, they're spending $8.4 million to close on that property tomorrow, but you say they don't have a proper plan?
No, they're in the process of designing and engineering those plans. That will probably, in my opinion, take more than a year to get done. But based upon the city's comprehensive plan, they can do all the engineering, designing, and everything else and get it construction ready, but they won't be able to put a shovel in the ground.
And that's due to the law? And that's due to the law, if you want to clarify the law?
The comprehensive plan law and also the interlocal agreement law.
Thank you.
Three quick questions. One, was the Volusia Growth Management Commission involved in any of these proceedings? Secondly, have you identified any wetlands on the Spring Vista site? And thirdly, what would be the venue for deciding this case? Would it be circuit court, or would you consider going to the state Supreme Court for a sort of immediate declaratory decision?
Well, I don't know exactly what the wetlands are on the Spring Vista site. The 6 acres, there are 2 parcels there. One's 23 acres, the other one's 6 acres. We do know on the 6 acres, there's 2.84 acres on the adjacent 6 acres they're purchasing. There's 2.84 acres of a drainage easement that the city owns that will have to be, if they were to purchase that property and continue and allowed to build there, there were some issues regarding that particular easement on that property. Trying to answer your question regarding how far the city's going to go, I don't know. That's going to be a question on the city council, and our city attorneys are going to determine that.
Was the Volusia Growth Management Commission involved in any of these reviews? Since it involved comprehensive plan, they're supposed to be sort of the court for deciding some of those cases.
No, but the statute's very clear that they had 30 days to file an appeal in circuit court, and they did not do that, which makes the comprehensive plan decision final and binding.
How long do you think a legal battle would take?
I have no idea.
Final questions?
Hi. Haley Brown, Hometown News, Volusia. I had a question about, so this has clearly frayed the relationship between the City of DeBary and Volusia County Schools, and you folks had been working towards that, to rebuild that. Is there any plan moving forward to continue working with Volusia County Schools to resolve this issue
Regarding the Spring Vista site?
regarding, like, just if they no longer move forward with the Spring Vista site?
Well, the city of DeBary has been working with Volusia County Schools extensively. We have, on DeBary Elementary, we had a significant traffic problem. Just like Shell Road in DeBary, High Banks it was a 2-lane arterial road. It was blocked every day for 10 years for 2 to 3 hours for parents picking up their kids. We worked with the school board in 2021 and 2022. We brought a proposal to them to split the cost of creating a turning lane and to build on their property 2 lanes going into their particular property to stack cars so that we can open up High Banks Road 2 to 3 hours a day. When the road is blocked like that, you can't get emergency vehicles in and out. And it was the city that approached the school and provided some concepts and preliminary engineering plans to get to an agreement where we split the cost 50-50. That was a $1.6 million project. And so we completed the construction of that particular project, and thank goodness it's working great. The cars go in and out, parents are picking up their kids, and High Banks remains open for the rest of the residents in our emergency vehicles. So we've been working extensively with Volusia County Schools for a long time. And so, yes, if they want to build on the 48 acres, we'll put everything aside and do everything we can to make it the best school that in Volusia County.
Okay. Thank you.
Thank you.
We have information on our website. If you go to debarry.org and type in school, you'll get copies of the interlocal agreement. There'll be copies of the letter. We also have copies of the letter that was delivered to the school board over there, as well as maps. And if you have any follow-up questions, those of you, if you have my contact information, my business card is over there as well, and you can also email info@debarry.org.